The Kerala High Court has ruled in a case that the offence of rape on false promise of marriage does not apply when the complainant was already married and continued in that marriage at the time of the alleged offence. The case here involved a police officer who allegedly promised to marry the complainant, had multiple sexual encounters with her, and also took around 9.3 lakh from her. He was charged under the IPC section 342 for wrongful confinement and section 376(2)(n, that is repeated rape on the same woman. Seeking to quash the charges, he approached the High Court. In his defense, the accused claimed that he initially intended to marry the complainant but withdrew after learning that she was already married and had 2 children, as a legal marriage was not possible. The High Court has ruled in favor of the accused, holding that since marriage was never legally possible, the sexual relationship was consensual. Justice A. Bahaduruddin observed that in such cases, the promise of marriage itself is an impossibility. For the charges to stand, it must be prima facie shown that consent was obtained through a misconception of fact, which was not the case here. The court explained that while obtaining consent for sexual intercourse by falsely promising marriage could amount to misconception of fact, but the situation here is different because the complainant is already in a valid marriage. The court further stated that in such cases, the very promise of marriage is baseless and therefore there is no misconception involved.